Everybody in this courtroom remembers me. I was just that.
You're hard to forget, Mr. Gilbert.
You can go ahead and let the officer know that you're done. You should be released here in the next day or so.
How about release me today, Your Honor?
I see Mr. Trammell in the back. Who's here on Mr. Trammell? Which one of you? No, he's not represented by counsel. All right, are you guys ready?
Yes.
Mr. Santos, Mr. Trammell? Mr. Trammell, come on. 26 CR 921 Trammell appearances.
Anthony Santos for the people.
And let the record reflect that we have Mr. Trammell here. We're set for arraignment today. Mr. Trammell, how would you like to move forward?
First of all, Your Honor, is this a court of record? Can I get a stenographic report of this proceeding?
No, we don't do stenographic recording. There's an FTR machine. It is being recorded. If you want a transcript after this hearing, you can request it.
Yeah.
How do you want to move forward? Do you want to enter a plea of not guilty so that we can get this case moving? Or do you want to reach a disposition and enter a plea of guilty? How would you like to move forward?
Can you repeat that, please?
We're set for arraignment today.
Yes.
At arraignment, you can either plead guilty or not guilty
Guilty or not guilty to what?
to the charges.
Which are?
You are charged in this case with possession of a dangerous weapon and large capacity magazine prohibited. And let me make sure that I give you the state statutory cites. Possession of a dangerous weapon pursuant to 1812-102 subsection 3, large capacity magazine prohibited during crime, 1812-302 subsection 1, subsection 1 AC. Now, what is your plea? Guilty or not guilty?
I'm going to plead guilty or not guilty. I have a question. I do have a right to know the cause and the nature of this
You can do
particular
that.
offense.
You're not going to do that today in court. You can seek discovery. You can communicate with the district attorney's office and you can ask for discovery. How are you moving forward today? Guilty or not guilty? That's what we're doing today. You're set for arraignment. I told you last time we were here, you wanted to, if you wanted to apply for an attorney, you didn't want one?
However, under the Sixth Amendment, I do have a right to know. It affords and guarantees me the right to know the cause and nature of this particular action.
Sir,
Ma'am.
you're
and it
set
is
for
your duty
arraignment.
to tell me what the cause and nature of the action.
You're set for
Is
arraignment.
this a criminal or civil offense?
This is a criminal offense.
Okay, so
sir.
under the Constitution, there's two jurisdictions. One is under the common law and the other one is a condition of contract on the colorable elements of a.
I don't know whether or not you're getting
Which
your.
two of these jurisdictions will you
Let me
hear
tell
this
you what
case?
you're not going to do today, Mr. Trammell. You are not going to interrupt me when I'm speaking. Do you understand me?
I'm not interrupting you.
Okay. Now, you are here for arraignment. And I'm
I
going to ask
understand
you
it, but you're not answering my questions. I can't adequately answer the question until
here
you
for
answer
two
mine.
criminal charges. Okay?
Okay, so is this common law or are we under the tolerable jurisdiction?
These are statutory, this is
Okay, but you're not
statutory.
answering my
This is not
question.
common law.
You're not answering my question. And I'm not interrupting you. I'm not being loud. I'm asking you a simple question. It's my right to know. And you're
Sir?
not telling me.
Sir, you are here pursuant to statutes. Okay?
You did not answer my question.
Okay. Sir, common law. Now,
Common law?
do you plead guilty or not guilty?
Okay, so we're under the common law. Where is the injured party? Under the
Sir?
common law.
Sir, the people are the injured party in this case. How do you plead guilty or
We'll put
not
the
guilty?
people on the bench then.
You're going to enter a plea of not guilty today.
So
We're
now
going to
you're
set you for
practicing law
trial.
from the bench, aiding the prosecution?
Where's the paperwork? Not
Let the
guilty
record
plea
reflect that
enters
Your Honor
today.
is practicing law from the bench and aiding the prosecution.
December 5th, 2026. Motions are due on July 6th, 2026. Your disposition date is scheduled for July 27th at 8:30.
You said July 6th?
July 6th, your motions are due.
And what was the other date?
And July 27th, you're set for disposition. If testimonial motions are filed,
27th?
the 27th of July. If you file testimonial motions, I'll set a motions hearing then. Thank you. Your speedy trial again is actually December 4th. We'll see you on July 27th. Thank you. Bond continues.
Your Honor, if the court is ready and willing, if we may next call the Gilbert matter, that is 26 CR 1349.
26 CR 1349, People versus Rainey Gilbert. Entries of appearance, please.
I'll make my conversation.
Brave Taylor on behalf of the people.
Good morning, Mr. Gilbert.
I got that for you.
I'm not bad, thank you. We're scheduled this morning for filing of charges. Mr. Gilbert appears out of custody in pro se, having posted an appearance bond on June 2nd. Mr. Gilbert, did you receive a copy of the one-count complaint that was filed in your case?
Yes.
And do you understand the general nature of what you're accused of in that count?
Yes.
I mean, we've got a smattering of stupid. It isn't very long. I've got one more after this, but this guy is an absolute flaming a-hole. You have to see it.
All right, you're charged with a single count of a class 6 felony criminal mischief that carries a maximum penalty of between 1 year and 18 months in the Department of Corrections, a maximum fine of $100,000 and 1 year of mandatory parole.
Yes, sir.
Do you have any other questions about that one count charged against you?
No, but I have a lot of questions. I have 99 questions, but I'm only going to ask you one. So as we're talking today, I'm going to compose it all into one question because I can hear myself on the mic speak.
Okay, what's that one question?
Well, let's move on real quick. I got to think about it.
You're going to think about your question?
Yes.
Okay. But you don't have any other questions about the charge?
No, my head hurts really bad.
Okay.
So I'm sorry that I'm a little slow. It looks like I'm drunk, but I got beat up twice, 2 days in a row.
Okay.
My face doesn't look different.
Yeah, I can see you got a swollen eye.
Soul and I,
Yep.
you're my judge. We saw each other yesterday.
A couple days ago, I think, yeah.
Thank you for making my court on Friday. Because after Friday, I have to go to the mosque and pray.
Okay.
So if you can get me out here, I'm going to go straight to the mosque and pray. I'm going to be good as hell. I fucked up my probation. That's why I'm talking to
Please
you.
don't use profanity in the courtroom.
Excuse me.
It's all right.
I messed up my probation. That's why I'm here.
Okay. All right. Well, sir, this is not a probation revocation case. You may have a probation revocation in a different case, but this case is predisposition rather. So this case has not been resolved yet. You are still presumed innocent until proven guilty. With respect to that one charge, you said you didn't have any additional questions about that. I'll just let you know that the charge that's been filed against you will not be eligible for a preliminary hearing in this division while you're out of custody. So what we're going to do this morning is set you for a next appearance in Division 309. That's going to be on the same floor down at the other end of the hall. That's the courtroom where your case will proceed. Do you have a plan for an attorney? Do you intend to apply for a public defender or hire private counsel?
So hold on, let me just summarize what you just said. Can you say it in 3 words?
3 words.
You have to go to court, say to court. 309.
Oh,
I got beat up, dude.
yeah. So
So I'm
your
helping
next
myself right
appearance
now.
after
Sorry.
today, we're going to set you for a new court appearance after
Okay.
today, about a month down the road.
About a month.
Yeah, it'll be about a month from now. We're going to give you a piece of paper that'll have that next court date on it, so you don't have to remember it.
Okay.
And you don't have to remember the division assignment either, because that piece of paper will have the new courtroom on it.
Yeah.
The new courtroom is 309. So it's on the same floor.
Okay.
It's down at the other end of the hallway.
Yeah.
And your future appearance, your next appearance will be in that courtroom.
Okay.
When you appear there, the judge is going to want to ask you about your counsel.
Okay.
So do you plan to apply for a public defender or court-appointed counsel or hire private counsel?
Public defender, please.
Okay. Do you have an application? Have you received an application for a public defender?
Yes, sir.
The public defenders have an office open in the courthouse this morning. It's up on the 4th floor in room 405A, 405A. I would encourage you to submit that application this morning up in 405A or as early as possible. And we'll set you for an appearance of counsel date down there in Division 309 in about a month, so you have some time to make that happen.
So not Division 302, it's Division 309.
Correct.
And I gotta come apply for a public defender. He's protecting public defender.
Yes, submit that application to the public defender's office and you can do it up in 405A on the 4th floor.
Better shape here.
All right.
All right, is there any?
Can I tell you something?
What?
This is my. Oh, hey, you remember me, right? Good God, everybody in this courtroom remembers me. I was just that.
You're hard to forget, Mr. Gilbert.
Oh,
Mr. Gilbert, do you have any other questions about
yes.
how we're proceeding?
I have another question.
You had a big question,
I composed my 99 questions
Perfect.
to one, like this,
All
like a
right.
sandwich. So let me eat it real quick. Guys.
Sir, please don't address the box. Please just address the court this morning.
Okay. Okay.
Put your sunglasses in.
Okay. Can you shake my hand? Ooh.
Mr. Gilbert, what's that last question you had?
So the $1 million question is, how do I apply to work here as a volunteer for my Muslim brothers that are inside the jail? So like, come here, give my sermon. It's not just Muslim brothers, Christians too, because my mom is Christian and my stepdad is Muslim.
Okay.
I want to be at chapel.
So I can't give you advice as far as that goes. I can't give you legal advice or employment seeking advice either as far as that goes. Ultimately, if you'd like to spread the word to others in the jail, ultimately you'd have to be in the jail. You can't just go in there as a citizen and do so. But I don't think that's where you want to be at the moment. So I would encourage you to maybe seek different.
No, but I'm saying I need to work, sir. I don't have work and I'm a pastor. How much is it for me to come and be a pastor at the court? Let's just think about that question.
I can't give you advice on that, sir. Mr. Taylor, is there anything else from the people on this case?
No, Your Honor. Thank you.
All right, Mr. Gilbert, you've got that setting slip, I believe. Did we already pass that out to him?
Be set for July.
Thank you.
No.
All right, Mr. Gilbert, that next court date, your bond will be continued through then. Please make sure you remember to submit that public defender application,
Okay.
and good luck with that application. Have a good afternoon.
You as well. What's your name, Judge?
Spanish.
My name is Casey Brown.
Judge Casey Brown.
Have a good day, sir.
Upstairs, okay? Right now, I've got something.
Sir, good morning in the Nisqually Jail. What is your name, please?
My name's Patrick Spitzer.
All right. Thank you, Mr. Spitzer. This matter is case 26L000686. Matter comes before the court today for a competency hearing. It appears that Mr. Spitzer was before the court previously on May 19th, 2026. There was a motion for a competency evaluation, which was granted by the court. It appears that a competency evaluation was completed by DSHS and filed with the court on June 1st. Mr. Wood and Ms. Tuanenga, have both parties received a copy of that competency evaluation and had an opportunity to review it?
Yes, Your Honor, and I have provided a copy to Mr. Spitzer, and I believe he's reviewed it as well.
Thank you. And it appears that based upon a finding of incompetency, the prosecution is moving to dismiss Mr. Spitzer's case at this time. Is that accurate, Ms. Tuanenga?
Yes, Your Honor.
All right. Does either party know? I don't have the competency evaluation in front of me. Did the evaluator make a recommendation regarding evaluation by DCR prior to release from custody?
I was just pulling it up. An evaluation by a DCR is recommended before his release from custody.
It is recommended?
Yes, Your Honor. Forgive me, I filled out the order prior to.
Oh, no, that's okay. I just wanted to make sure. Mr. Wood, my typical practice is to follow the recommendation of the evaluator, and so I'm inclined to sign this motion in order of dismissal prepared by the prosecutor, but I'm also inclined to instruct the Nisqually Jail to not release Mr. Spitzer until he is spoken with and met with a DCR. Is there any objection to that?
I do. There's an objection here, sir.
Okay, Mr. Spitzer. Okay, Mr. Spitzer, let me give your attorney a chance to talk to me, okay? And then I understand you object, but I want to hear from you.
Look, it's a misdemeanor, Your Honor. It's a misdemeanor. Let me
I know.
go.
Sir,
I gotta go home.
Sir, I advise letting me do the speaking. If you would like a breakout room, we can certainly talk offline, not on the record if you have concerns, sir.
Okay.
I was going to relay to the court, and if you have an issue with this, we can definitely talk about it. My request to the court was going to be to have you released, sir. But I will defer to the court about the DCR, but defense's request is that Mr. Spitzer be released from custody.
Please, Your Honor.
Mr. Wood, thank you. Mr. Spitzer, thank you. Ms. Tuaninga, anything from the prosecution regarding that limited issue?
Ma'am,
Based on the
I missed
request
that.
of the evaluator, the city is going to be requesting that Mr. Spitzer be checked out by a DCR prior to his release.
why do I need to be checked out by a DCR, your ma'am? Why do I?
Mr. Spitzer, here's the thing, sir. The criminal case is being dismissed. I wanted to hear from you. I wanted to hear from your attorney, and I wanted to hear from the prosecutor. But here's the thing. The legislature has indicated that there are certain situations where somebody may not be competent, and before they're released from custody, we want to make sure they're not a threat to themselves or anybody else.
I'm nobody's threat.
I don't disagree with you, but I'm not a trained mental health professional either.
Your Honor, I've never attacked no one. You check my record. I am a solid citizen most of the time. I've never abused nobody. I don't hit people. I might raise my voice, but I'm not a violent person. I don't like violence.
Yeah. And Mr. Spitzer, I believe you. And I'm going to take a look
Let me go, Your Honor.
I'm taking a look at your criminal history right now. Hold on one second.
There's no violence. I was harassed very badly in my hometown, so bad that they caused me to have a nervous breakdown and a stroke. They caused me.
Mr. Spitzer, the judge is looking at your criminal history. He's going to rule on our request.
Thank you.
If you have concerns and you would like a record to be made to the court, we can absolutely get a breakout room and speak, sir. But I would advise against making statements about your situation on the record to the
I'm
court.
about my situation. I'm talking about me. What
Yes.
I've gone through.
I understand, sir.
My house and injecting me in something. It's scaring me to heck about being in my own home. My own manager gave the cops my key to my apartment. I don't even know why. And that scares me, your prosecutor. I'm not hurting nobody. I'm getting really scared about your police being sound.
Mr. Spitzer, I tend to believe you, but I'm going to err on the side of caution. I am going to order that you be evaluated by a DCR prior to your release. I've indicated on the order that needs to occur within 48 hours, or you are to be released at that time regardless. So hopefully they're going to be meeting with you here in the next 24 hours, okay?
How much? What was that, Your Honor?
I've told the Nisqually jail not to hold you any more than 48 hours, right? So hopefully they're going to come in and see you sometime later today or tomorrow.
Wait, if she comes in and says I can go, can I leave?
Yes.
I need
Yes.
to go home.
Once the DCR, Mr. Spitzer, you got to listen to me. Once the DCR meets with you and concludes or confirms that you are not a threat to yourself or anyone else,
I don't want to hurt
then at that point in time, Mr. Spitzer, you got to let me finish. At that point in time, they're going to release you, okay? But we want you to have that conversation with them
I
first.
don't need a DCR, Your Honor.
I understand, sir. I understand your position.
I'm supposed to get out today so I can go get my job. I work for.
So, Mr. Spitzer, like I said, you're not going to be held very much longer. We just want you to have that conversation with them first.
Your Honor, I need to go home. If you want me to go check into a hospital, I'll walk out and go to St. Joe's and check in. I'm not a violent person. I don't hurt people.
I believe you. Okay, Mr. Spitzer, your hearing is done, sir. You can go ahead and let the officer know that you're done. You should be released here in the next day or so.
How about release me today, Your Honor?
Okay.